Hey y'all, Rob here with ATX.Legal, and today I'm going to answer a question that a lot of my clients have when they first come to me, and that is, will a pending charge cost me my job? And look, this isn't strictly a legal question. The answer is not going to be found in any statute or case law because it's really up to each individual employer. Texas is an at-will state, which means they can fire you for basically any reason at all. Certainly a pending charge, no matter how minor, is going to be enough for them to legally be able to fire you. But whether they fire you or not is really up to each individual employer. So first, let's talk about how your criminal history works. So when you first get a charge and you're arrested, that charge will show up as an arrest and potentially as a pending case if you have a case that's going on in court. And potentially your employer is not even going to be monitoring that situation. So if they're not checking your criminal record, if they're not signed up to a service where they check it once a week, then they might not even find out about the arrest. And I'll talk to my clients on a case-by-case basis as whether it's a good idea to go ahead and report that to your employer. Sometimes when you've signed an employment contract, you've agreed that you will notify your employer within X amount of days after you've been arrested. And if that's the case, you should do it, because if you don't do that, it's a violation of your employment contract, and that alone could be the basis for them to fire you later, even if you get your charge dismissed or you don't get a conviction off that charge. But even if they're not monitoring your criminal history, even if you're not required to report it, sometimes word just gets around. If you've missed a day of work and they're calling around to ask why, or if you've told a coworker, word tends to travel, and sometimes the employer is going to find out that you're arrested, and then they can go and look up the charge, and then it will be up to them how they're going to proceed. And how they proceed is going to be very dependent on what type of work you're doing. If you're in construction, or if you're doing other contract work, a lot of times those employers are going to be more comfortable with a criminal history. They hire a lot of people with a criminal record. They're used to it. They know how to deal with it, and it's oftentimes not going to be a problem. But even in these situations, if they're going to see you as less reliable because you're going to have to be attending court every month, or you might have to attend classes or do other things that's going to keep you away from work, some employers are going to have a problem with that. So it's going to be a case-by-case basis, very dependent on each employer. Even within industries, different employers have different policies. And another thing to consider is the charge matters. If it's a misdemeanor DWI or another what's considered a more minor issue, that might not be a problem. Whereas if it's a felony charge, if it's a family violence charge, even at the misdemeanor level, these can have a more significant effect. So what you're charged with is going to have an effect on how the employer deals with the situation. And even a DWI can be a problem if your work involves driving, because that can be an issue for their insurance. Another question I get from clients is if they are facing questions from their employer, and they ask me, is there anything we can do? What can we do to mitigate this? And oftentimes there are ways to mitigate. Now we have to first distinguish what we're dealing with here. If you're dealing with kind of a faceless HR where they have a strict policy that's maybe based on their insurance, where their insurance tells them no employees with a criminal history, no criminal background, sometimes they have the line at pending cases. And if that hard line is there, there's really not going to be much you can do about it, and even HR's hands are going to be tied at that point. And that applies to some percentage of jobs, but I wouldn't say that's the majority. Usually the employer is going to ask you, okay, what's going on with this case? Is this going to be a conviction? What's happening here? Oftentimes I'll write a letter to the employer saying, look, this case is going to be on a dismissal track. We're negotiating this. It's pending right now. And I'll just give a little bit of background as far as what's going on with the case, of course, in the best possible light for my client. And a lot of times that's all the employer needs to keep you on. Most of the time, these employers are not going to want to lose a worker, especially if you're a good worker for them. And they're going to work with you to try and keep you on. Now, the more serious the charge, the harder that conversation is going to be. But for minor charges, for DWIs, other misdemeanors, a lot of times that simple letter from an attorney is going to be enough to keep you on and working. But the ramifications for your employment is something to consider that might technically be outside the bounds of what a lawyer is normally going to be helping you with, but I definitely try to keep my clients working. If there's anything I can do to help with those communications with the employer, I definitely do that in my practice. If you're meeting with attorneys, it might be something that you want to ask them if they'll be dealing with your employer at all if you need that, because some lawyers are simply going to tell you, no, I don't handle that. That's not part of what I do. If you are facing criminal charges, of course, none of this is legal advice, but if you would like legal advice on your particular matter, you can give us a call or you can visit us at ATX.Legal.